We begin our study of state power limitations with the Dormant Commerce Clause, often abbreviated as the DCC. This crucial concept is not explicitly written in the Constitution, rather, it is in implied restriction on state authority. The DCC arises directly from the Commerce Clause found in Article 1, Section 8, Clause 3, which grants Congress the power to regulate commerce among the several states. If Congress has the power to act, the states are implicitly forbidden from acting in a way that unduly burdens or discriminates against interstate commerce. Think of it as the negative implication of Congress's positive grant of power. When a state law touches upon interstate commerce, the judiciary steps in to ensure national economic unity is preserved. To effectively analyze these complex challenges, we must follow a strict, multi-step analytical framework. This framework is specifically designed to catch even the most subtle forms of state overreach into the national marketplace, ensuring a truly free trade zone across state lines. Having established the source of the Dormant Commerce Clause, we must now examine its core purpose. Why did the founders intend for this implied restriction to exist? The fundamental rationale is twofold. First, to prevent economic protectionism, and second, to avoid national market fragmentation. States, left unchecked, possess a natural incentive to pass laws that benefit their local businesses and residents at the expense of those outside their borders. This tendency toward favoring in-state economic interests over out-of-state interests is precisely what the Dormant Commerce Clause seeks to outlaw. If every state erected trade barriers, the result would be economic balkanization, the United States fracturing into numerous isolated, competing economic zones. This directly undermines the constitutional goal of creating a unified national market, which is the positive corollary to Congress's affirmative power to regulate commerce among the states. Therefore, the Dormant Commerce Clause acts as a constitutional shield ensuring free trade flows across state lines. That shield against protectionism is not applied randomly. Courts utilize a highly structured, two-tiered analytical framework to determine if a state law violates the Dormant Commerce Clause. This framework is crucial for navigating the complexities of modern commerce regulation. Tier 1 asks the fundamental question: is the state law discriminatory? Discrimination is assessed either on its face, meaning the text explicitly treats out-of-state commerce differently, or in its purpose, meaning the law was enacted specifically to benefit in-state economic interests. If the answer to Tier 1 is yes, if the law is discriminatory, it faces strict scrutiny, leading to near per se invalidity. This is the highest hurdle. If the law survives Tier 1 because it is deemed neutral in both text and purpose, we proceed to Tier 2. Tier 2 asks: does the law impose an excessive burden on interstate commerce? This involves balancing the local benefits against the national burdens, which we will explore in detail later. For now, visualize this structure. First, check for discrimination. If found, the law likely fails. If not, then check for excessive burden. This decision path dictates the fate of nearly every Dormant Commerce Clause challenge. We now move directly into analyzing the first major trap: facial discrimination. This occurs when a state law, on its face, explicitly treats out-of-state commerce differently than in-state commerce. Think of a statute imposing a higher license fee on non-resident truckers, or an outright ban on importing certain goods from other states. When a law is facially discriminatory, the court applies the most severe standard, strict scrutiny. This standard is so demanding that the law is considered per se invalid on its face, unless the state can meet an almost impossible burden of justification. The state must prove the law serves a legitimate, non-protectionist purpose, and that no less discriminatory means are available to achieve that purpose. Critically, The only common justification that typically allows a facially discriminatory law to survive is when the state is acting not as a regulator, but as a market participant. We will explore that crucial exception in our next segment. As we noted, the market participant exception is the critical escape route for a state facing a facial discrimination challenge. This exception applies when the state is not acting as a sovereign regulator imposing rules on others, but rather as an active participant in the marketplace. Think of the state wearing two distinct hats. When the state wears the regulator hat, it is bound by the Dormant Commerce Clause and cannot favor its residents. However, when the state dons the market participant hat, acting as a buyer purchasing goods, a seller disposing of resources, or an employer hiring labor, it is generally free to favor its own citizens. For instance, a state-owned cement plant can choose to buy raw materials only from local suppliers, or a state university can give hiring preference to in-state residents for non-academic positions. The rationale is simple. The Commerce Clause restricts the power to regulate interstate commerce, not the power to engage in commerce. This distinction between regulating and participating is vital for understanding when strict scrutiny is avoided. We just covered facial discrimination and the market participant exception. But what happens when a state tries to hide its protectionism? This brings us to trap number 2, substantive discrimination, often called discriminatory effect. The Supreme Court recognizes that a law might look perfectly neutral on its face. It applies equally to everyone, yet still violate the Dormant Commerce Clause. This occurs when the law's true purpose or its unavoidable practical effect is to shield local economic interests from out-of-state competition. While courts look for evidence of protectionist intent, sometimes the effect itself is so overwhelmingly one-sided that intent becomes secondary. If a facially neutral statute disproportionately harms or excludes interstate commerce simply to benefit in-state actors, it is deemed substantively discriminatory and will face strict scrutiny, just like a law written with explicit bias. This is where the shadow of protectionism falls. Now that we have navigated the traps of facial and substantive discrimination, we transition to the second tier of Dormant Commerce Clause analysis. This tier applies when a state law is deemed facially neutral and lacks a clear protectionist purpose or effect. We are now examining laws that regulate commerce incidentally, rather than intentionally targeting it. This brings us to the famous Pike balancing test, derived from the Supreme Court case Pike v. Bruce Church. The rule here is straightforward but requires careful application. The burden imposed on interstate commerce must not be clearly excessive in relation to the putative local benefits achieved by the statute. Visually, we represent this as a comparison, the negative impact versus the positive outcome. If the scales tip too far toward the burden side, the law falls. Specifically, the burden must be significantly outweighed by the local benefit. Courts generally uphold these non-discriminatory regulations unless the resulting burden on interstate commerce is truly disproportionate, or if the claimed local benefit turns out to be illusory or extremely minor. This is the standard for incidental burdens. We have now covered facial discrimination, protectionist purpose, and incidental burdens under Pike. Our third major trap concerns jurisdiction. Extraterritoriality. This principle dictates that a state cannot regulate conduct that occurs wholly outside of its physical borders, regardless of how significant the local effect might be within that state. This is a critical boundary. States often attempt to use their local market power to dictate terms for national transactions, such as setting price caps for goods manufactured and sold entirely elsewhere, or mandating specific supply chain behaviors that originate outside the state. If a state law attempts to govern activity outside its territory, It runs afoul of the Dormant Commerce Clause because it is effectively regulating interstate commerce beyond its legitimate sphere of authority. Think of it as an overreach of regulatory reach. If the line of regulation extends past the state boundary, it is likely invalid under the extraterritoriality doctrine. We have just concluded our review of the third major trap, extraterritoriality. Now, as we wrap up the core analytical traps, we must address a common point of confusion, distinguishing the Dormant Commerce Clause from the Privileges and Immunities Clause found in Article 4. While both clauses restrict state protectionism, they protect different things. The Privileges and Immunities Clause guards against discrimination against out-of-state individuals concerning fundamental rights or basic livelihood opportunities when they travel or move between states. Think of it as protecting the rights of the traveling citizen. The Dormant Commerce Clause, conversely, protects the free flow of goods and commerce generally. Crucially, the Dormant Commerce Clause applies to burdens placed on interstate commerce, which includes burdens placed upon corporations, not just individual citizens. So, Privileges and Immunities focuses on individuals and fundamental rights. The Dormant Commerce Clause focuses on the movement of commerce itself, regardless of whether the entity burdened is a person or a company. Having clarified the distinction between the Dormant Commerce Clause and the Privileges and Immunities Clause, we now consolidate everything into the essential tool for exam success, the Dormant Commerce Clause Application Checklist. Mastering this four-step decision tree is crucial. First, ask, is the state action actually a regulation of interstate commerce? If the answer is no, the Dormant Commerce Clause does not apply. Second, if it is a regulation, is the law facially discriminatory? If yes, the law is presumed invalid, subject only to the narrow market participant exception. Third, if the law is facially neutral, we proceed to the Pike balancing test. Does the burden on interstate commerce clearly outweigh the putative local benefits? If the burden is excessive, the law fails. Finally, check for extraterritoriality. Is the state attempting to regulate conduct occurring wholly outside its borders? Reviewing these 4 points, regulation, discrimination, Pike balancing, and extraterritoriality, will guide you through virtually every Dormant Commerce Clause question on the bar examination.